respond to your question. So now to introduce our fourth speaker, our fourth speaker is Dr. Melissa Loja. She is a senior research fellow of the Integrated Development Studies Institute, and also she serves as consultant on international law and international energy law in various agencies. She is the vice chair and lecturer in the International Law and Maritime Law Department of the Philippine Judicial Academy. Ladies and gentlemen, let us welcome Dr. Melissa. Dr. Melissa, please proceed. Thank you very much.
Right. Thank you for the kind introduction. Good afternoon, everyone, especially for the panelists from China. I feel that this is some form of simulation. So let me give my three main points for this presentation. The first main point is that the conditions. So the first main point that I wish to make is that the current condition, domestic condition in the Philippines, is not conducive to joint development. It is slightly conducive to joint exploration, but I will qualify. It is slightly conducive to purely commercial cooperation onshore. It is not so conducive to purely commercial cooperation offshore, and I shall elaborate later. The second main point I wish to make is that the MOU is not lost. It can be salvaged. And the final point that I shall make is that we have to move on from joint development. We have to end our obsession with the concept and theory of joint development and rethink some expanded form of cooperation in the South China Sea. And I shall explain why I say this. So in response to the questions raised by the organizers, let me present my response in three parts. The first part is on the current state of the environment for cooperation. The second is on the status of the MOU. And the final part would be on the lessons that we can use moving forward. So on the current state of cooperation, let me examine three forms of cooperation based on our experience. The current status of cooperation in the Philippines can be examined based on three experiences. The first one is on the joint marine seismic undertaking. Now, this was an agreement among the national oil corporations. This was not an intergovernmental agreement, although later on, the agreement was formalized by President Arroyo and the ambassador from China and the ambassador from Vietnam. Now, under this agreement, the two national oil corporations will engage in a survey of an area, which in my presentation is shown by the broken brown lines, in an area which consists of the EEZ and continental shelf of the Philippines. Second, the territorial sea of rocks occupied by China and Vietnam and claimed by the Philippines, and the territorial sea of rocks occupied by the Philippines and claimed by China and Vietnam. Now, the opposition from the part of the Philippines to the JMSU, or by some groups in the Philippines, was that the GMSU, number one, covered mostly areas that are claimed or that belong to the Philippines. Of course, it's a claim, but of course, that was the basis of their opposition. And also because there is a provision in the Constitution of the Philippines which provides that when it comes to resources, including resources in the EEZ and the continental shelf, the utilization of these mineral resources will have to be exclusively for Filipinos. So that was the basis of the opposition to the joint marine seismic undertaking. Now, based on that experience, one can say that there's almost zero possibility of a joint exploration. But I will explain why that is not the case, that there is a chance for some form of joint exploration. Now, the second experience we had was the MOU in 2018. Now, the termination of this, the speech of Secretary Locsin is not really clear on whether there was a termination of the MOU, the termination of the formal negotiations under the MOU, or the termination of the informal negotiations under the MOU. The speech merely says that the objective of the Philippines was for oil and gas cooperation, and that there was going to be a termination of negotiations that was undertaken for the period of 3 years, and that the termination is final, and because the reason for the termination are constitutional obstacles. So that was the presentation of Secretary Locsin, and I will discuss why there is still a chance to salvage the MOU even with the speech of Secretary Locsin. I will do so in the second part. But finally, I consider as a signal or an indicator of the receptivity of the domestic audience to cooperation with China, any purely commercial licensing cooperation taking place between a Chinese International Petroleum Corporation and the Philippine government. And here there is an indication of receptivity when it comes to a productive service contract. And this is in onshore service contract 40 in Alegria, Cebu. But there's also another ongoing service contract, and that is service contract 70 under Polyart, and that is a Hong Kong-based International Petroleum Corporation. And to those two petroleum corporations, there is an ambivalence, not really in the sense that the domestic audience supports the two corporations and their undertaking, but more or less a lack of resistance to that form of undertaking. In contrast, when it comes to offshore, there is a resistance even to a Filipino corporation such as Udena assuming operatorship or assuming operatorship or taking participation in service contract 38 under the suspicion that Udena is actually a Chinese interest corporation. And that resistance is indicative of what could happen if there is some form of cooperation between China and the Philippines offshore. And we have to remember that service contract 38 is not even disputed. Although service contract 38 straddles the 9 dash lines, China has never claimed service contract 38 as its own or has never stopped any oil and gas activities in service contract 38. And yet the resistance, the strident resistance to Udena is borne out by suspicions of Udena being actually a Chinese investment or harboring Chinese investment interests. So based on these three factors, one can say that there are contradictory aspects in the existing condition for cooperation between China and the Philippines in oil and gas. And the first one, of course, is that when it comes to joint development, there will be resistance based on the interpretation of the arbitral award that there is no overlap between the Philippines and China, especially when it comes to the EEZ and the continental shelf. Even the definition of Professor Gao would support the view that joint development presupposes the existence of an EEZ-CS overlap. Very rarely is there a joint development in an overlap involving territorial claims. It's mostly maritime claims in the EEZ and the CS. The possible example of a territorial claims having a joint development is the one in the Persian Gulf or in the Middle East. But nonetheless, in the Philippines, there will be resistance to any form of joint development. And by that, I mean the classical form of joint development where there is a defined area in an overlapping zone involving two opposite or littoral states, and the overlap is between CS and EEZ, but not CS, EEZ, and TS. There has never been a joint development between two different categories of maritime zones, and that joint development being one where there will be sharing or almost equal sharing of ownership and operational authority, as well as almost equal apportionment of proceeds. No. So based on what I explained, there will be resistance to such an idea. With respect to joint exploration, I think there will be also resistance if the joint exploration area is as extensive as the JMSU area, where there are more Philippine EEZ and CS is covered by the area and less coming from the part of Vietnam and China, although it has been lost to most commentators about the JMSU, that what is covered by the area of the JMSU is not just the EEZ and CS of the Philippines, but no less than the territorial sea of the rocks that is found, that are being occupied and claimed by Vietnam, China, and the Philippines. So also there has to be some consideration of the participation of Vietnam in any form of joint development or joint exploration if we are to have a stable environment in the South China Sea. But let me point out that in 2014, the ambassador of Vietnam, from Vietnam, proposed to the Philippines some form of joint exploration. But I looked into the reaction from politicians and from commentators in the Philippines and found no comment at all, no resistance, no objection, as though there would be no problem if Vietnam would raise the idea of joint exploration with the Philippines. But since 2014, there has been no concrete steps towards that direction. So I'm not sure if that has progressed at all. Now, of course, when it comes to purely commercial cooperation, as I mentioned, there is domestic resistance and as well as ambivalence, depending on where the commercial undertaking of a Chinese investment corporation is taking place, whether it's onshore or offshore, and whether that particular undertaking is visibly productive. So based on these contradictory aspects of cooperation, I might summarize and conclude that at the present, the environment is shaped very much by geopolitics. And it is rationalized by a particular legal narrative that has not been challenged formally or even in a widespread manner by any other commentator from both the geopolitical as well as the international law fields. But given the contradictions open the door for correction, the environment can also be reshaped, and it can be reshaped through economic pragmatism rather than geopolitics, and that economic pragmatism might become the dominant factor as the Philippines faces an energy crisis brought about by the current global events. Now, in order for a commercial undertaking by, I have moved. Sorry. In order for a commercial undertaking by China to be that needs to be received well by the Philippines, whether it's onshore or offshore, maybe there is a need for that particular undertaking to be visibly productive. And in that way, the environment might improve for purposes of engaging in cooperation. But when it comes to joint exploration and development, there will be some resistance in terms of narrative based on what is shown on the screen as Section 2, Article 12 of the Philippine Constitution, which expressly says that mineral resources will have to be utilized exclusively by Filipino citizens. However, the same provision contains an exception to the general rule, and that exception states that the president may enter into a financial, which are high risk investment contracts, financial or technical agreement with a wholly owned foreign corporation for purposes of mineral extraction, oil and gas extraction included. And this particular exception has been interpreted by the Supreme Court to mean that service contract, petroleum service contracts, onshore or offshore, may be issued in favor of a foreign corporation, and that therefore oil and gas sources are exempt from the general rule under Article 12, Section 2. And the only conditions imposed by the Supreme Court is that, number one, there has to be a law existing authorizing such licensing to a foreign corporation, such as a Chinese corporation, offshore or onshore. And that second, there has to be an agreement or adoption of the agreement by the president himself or herself. And in this case, the onshore contracts of China meet all the requirements, and at the same time, the offshore contracts will have to meet those requirements. The objection of exclusive utilization by Filipinos is a legal narrative that can be modified, especially if the Philippine Supreme Court decides on the existing petition on the constitutionality of the joint marine seismic undertaking. And I think that most commentators and most interest groups have completely ignored that the Supreme Court is a battleground for narratives about the South China Sea. And in any event, of course, as I said, joint development is conceptually problematic for the Philippines, especially in the light of the arbitral award. Now, we can say, of course, that the arbitral award can be set aside, but to do so would be to modify the status quo ante, that is, the status quo before the 2018 MOU. Remember that our starting point is the 2018 MOU, and at that point, there was already an arbitral award. And if the Philippines will have to abandon the award in order to proceed with the negotiations, then it would, in fact, be accepting a very different status quo, which is not favorable to Philippine interests. Now, what then is the state of the MOU? Is there MOU the way forward for the Philippines and China in terms of negotiations? Now, when Secretary Locsin canceled made a speech about the termination of negotiations, it was not clear exactly what Secretary Locsin was referring to. And therefore, let me examine the implications for whether Secretary Locsin was terminating the MOU, the formal negotiations, or the other types of negotiations. And let me go to first the remarks of the Secretary, and let me break it down into the following. First, the Secretary mentioned the termination of a 3-year negotiations. Okay. Second, he said that the obstacle to further negotiations is constitutional on the part of the Philippines, and that as a result of the termination of the 3-year negotiations, there is now a failure on the part of the Philippines to adopt a form of arrangement that would allow for development of oil and gas resources. So that is the context of the speech. Now, I have not seen any official statement or communication for the termination of the MOU. But in any event, let us assume that the Secretary was referring to the MOU. Let me begin by registering a contrary view to that of Professor Gao when he said that the MOU is an international instrument. For me, the MOU is not a substantive agreement. It is not at all a treaty. And this is so based on an express provision of the MOU itself, and that's Section 4. which says that it will not generate rights and obligations under international law or domestic law. And we know that an international instrument is precisely that, a source of rights and obligations. And if the MOU is not a source of rights and obligations, then it is not a treaty. Okay. Now, what is it then? It is a mere agreement to agree. And there are various aspects that were agreed upon by the two parties. First, it was an agreement as to the output of negotiations. And here it is important to point out that what was agreed upon as a possible output is a form of arrangement to facilitate oil and gas exploration and exploitation. Here, there is no mention of joint development. It can be any form of arrangement, and we have to be creative as to the form of arrangement that we can negotiate on and eventually adopt. And it will be an arrangement on oil and gas exploration and exploitation in a relevant maritime area. There is no definition of the cooperation area. And finally, it will have to be consistent with international law rather than with the domestic laws of the two countries. And of course, by international law, here we mean some form of a bilateral agreement or maybe even a functional agreement between the two parties that would then be the source of rules and rights and obligations within that cooperation area, whatever that might be. At the same time, it was an agreement to mechanisms, including principles that will govern the behavior of the parties. And therefore, if we say that what was terminated was the MOU, then that would be disastrous. That would bring us back to the Stone Age, because then all of these agreements will have been abandoned. And that for me would be a shame. Nonetheless, if we assume that what was terminated was a formal negotiations, again, I would disagree. Why? Under the MOU, there was an agreement as to the structures for negotiation. First was the Intergovernmental Joint Steering Committee and the Inter-Entrepreneurial Working Group. Now, the first and only meeting of the committee was on October 28, 2019. No other meeting, no other formal negotiation took place thereafter. And I think this is where the two parties failed each other. There should have been a sustained formal negotiation rather than the hijack of the negotiations by private entities. In this situation, there was already a committee. They met in October. They agreed, in fact, and if you look at the minutes of the meeting, they agreed to establish a legal and technical working group that would then propose various forms of cooperation arrangements and even various areas for cooperation. It was the most important step in this negotiation, but unfortunately, for some unknown reason, the legal and technical working group was never established. And I think if we are to restart negotiations under the MOU, the first order of the day should be the immediate constitution of the legal and technical working group. It could be separate legal technical working groups on each part, and for them to come up with a working negotiating text within 30 days, if possible. That's just my view. And anyway, and of course, the other structure would be the Inter-Entrepreneurial Working Group. Now, this group, the Inter-Entrepreneurial Working Group, was not constituted at all, because the existence of this group depends on the agreement that will be forged by the committee. As no negotiation took place at the committee level, no agreement was achieved or adopted at the committee level, there was therefore no Inter-Entrepreneurial Working Group to speak of. So if one would say that the formal negotiations were terminated by Secretary Locsin, I very much doubt that that is the case, because there was no formal negotiation at all. Instead, there was some form of direct but informal yet full negotiations between Forum, PXP, and the Ministry of Foreign Affairs and China National Offshore Oil Corporation. In all these negotiations, there was no Philippine government representative present. And there were the talks about the cooperation area, the modalities of cooperation, as well as the allocation of costs and proceeds. Now, this took place over a period of roughly 3 years. And I would say that this was the negotiations that Secretary Locsin announced to have been terminated, rather than the MOU or the formal structures for negotiations under the MOU. And I think that Secretary Locsin was justified in terminating this type of negotiations, as I will explain later. So in response to the second question of the organizer, yes, there was a termination, but the termination referred to the other negotiations rather than to the MOU itself or the formal negotiations at the committee level. And I would say that the termination of that type of negotiation was justified, as there were a number of problems raised by Secretary Cusi regarding the authority of the private entities, the scope of their negotiations, the area for negotiation, as well as the terms of negotiation. Remember, as I said, the MOU did not create rights and obligations, and that includes the capacity to amend Philippine laws. And under Philippine laws, especially Presidential Decree 87, it is only the DOE that can engage in any form of negotiation regarding areas for oil and gas, as well as the commercial terms for oil and gas. There would be need for an amendment of PD 87 before that can happen. So the MOU is not a law that can amend Presidential Decree 87. So structurally, it was already very problematic. So moving forward then, what lessons can be learned given the conditions, the structural contradictions for joint development? As I pointed out, we have to argue that there is an overlap, where even if there is no such overlap under the arbitral award as the Philippines have adopted. And also we have to examine the status of the features that will be covered within the cooperation area, especially as these features are territories and they are occupied by Vietnam and China, as well as the Philippines, and they are claimed by these three countries as territory, including the territorial seas generated from these rocks. Now, also, because of these structural contradictions, every negotiation on joint development on oil and gas cooperation that focuses on joint development ends up in a binary between joint development or farm-in, ownership of resources in situ or at the wellhead, or non-ownership, as well as problems about operational taxation and other legal jurisdictions. So my view is that we have to be creative and look outside, think outside of the box. And for me, these are just my views. We need to step back and look at the whole, the entirety, the range of relations between the Philippines and China. And we, as far as I'm concerned, I think that the underlying interest of China is not at all economic gain. It is not after oil and gas resources per se. I think the primordial interest of China, especially in the current situation, is for maritime security and a buffer zone in the South China Sea. I think this is a provocative statement coming from me. I am not a geopolitical expert, but I think if we just go down into the basics, I think that is the red line as far as China is concerned. Now, for the Philippines, the red line is loss of sovereign rights, or maybe loss of sovereignty, of course, when it comes to the rocks. But the interest that we hold when it comes to negotiations for oil and gas is simply energy and food security. And therefore, also, of course, we need to consider the interests of the international community, and which is freedom of navigation in the South China Sea. It cannot be avoided. The South China Sea has been the site of freedom of navigation for years. And therefore, the only approach, the only possible avenue for cooperation is not one solely for oil and gas, and not one focused on joint development. I think we need to adopt, and I think we need to consider already, a 4-layered multi-purpose zone, which takes into account the safety and security interests of the parties, the fisheries interests of the parties, as well as the oil and gas, and of course, maritime trade by the international community. And I say this because at the end of the day, we need for everybody to come to bring home something. And for the Philippines, we have to bring home energy and food security without losing any particle of sovereignty. And for China, I think, given the distance of the area from the coast of China, and given its existential interest in the South China Sea, I think that your interest would be served if we are to design a safety or security buffer zone agreement of some form. I'm not suggesting any specific one. Under international law, each platform is entitled to only a 500-meter safety zone, but I don't know what can possibly be adopted as a security arrangement or a safety arrangement. I'm not sure. That is something for the experts to negotiate on and to think about. And of course, for this reason, there is need for us to expand. There's need for us to expand. Okay. There is need for us to expand the legal technical working group to something like a legal technical security fisheries working group. So it will have to be a very functional negotiation rather than one that is normative. And finally, if we look at the best practices around the world, we can just imagine the range of cooperation that has been undertaken when it comes to oil and gas, and the methods that have been adopted. And let me just mention, for instance, the Maritime Boundary Agreement between Netherlands and Venezuela, where there is a provision that triggers a resource clause, that if they find a resource that straddles the boundary, then automatically there will be a negotiation, a consultation and negotiation for how to deal with a shared resource. The other form is a more detailed resource clause, such as between Equatorial Guinea and Nigeria, because that particular clause, compared to the one between Netherlands and Venezuela, that particular clause already details who has authority to negotiate, what will be the form of negotiation, will it be unitization, will the definition of the area be field specific, meaning should there be first a detection of a field that straddles the boundary, or could it just be a joint development area where there is no field that is established yet? Of course, there is also the joint development agreement between Japan and South Korea, which already delineates a zone and leaves everything else to further negotiation. And another form of joint development agreement between Malaysia and Thailand, where they only created a legal entity, a third legal entity that will then adopt certain provisions for purposes of carrying out the joint development. And for me, the more important, the more relevant agreement, is that between, I can't even see, All right. For me, the more relevant and the easiest to adopt is a form of agreement between the national oil corporations of two countries, or even just the petroleum agencies of two countries. And here I refer you to China and Vietnam, both of which have a joint exploration agreement dating back to 2013. And that agreement was amended in 2015. And the zone for exploration was expanded to go beyond the limitation line in the Gulf of Tonkin. And there's also, of course, a joint JD and unitization agreement that can be found in the contracts, existing petroleum service contracts of the two countries, such as the one of Vietnam, where there is a provision that says that if a field is suspected to straddle a boundary, then there is an automatic, then the process is triggered where there is a negotiation taking place between national oil corporations. Thank you very much. Sorry for the technical difficulties.
Thank you very much, Dr. Melissa. I think for that very straightforward, really thought-provoking presentation. I think for me, my takeaway, and also there are so many things that I've learned from your presentation. But I think one thing that is important is the clarification about the MOU, that, it was canceled, but, you've explained it very well. And on the other hand, that there's such a thing as, that we can salvage what the MOU, and it's not lost forever as what other people have perceived because of that speech or interview with former Secretary Locsin. And also, I think it's very good as well that you've addressed the limitations of the constitution of the country, of the Philippines, vis-a-vis any kind of joint oil and exploration or joint gas and oil exploration in anything that is considered to be part of the Philippine territory, or we have a so-called sovereign rights. But you've explained it that there are, we need to be creative about all these things, that we need to think out of the box for us to be able to push forward what is good for both country. And one thing that I also like in your presentation, I think, is to look at the whole problem or the whole situation from a macro perspective and consider everything. And one thing that I agree with you is, yes, the geopolitics is also one of the most important consideration in the discussion of all these things. If we really want to address the issue holistically speaking. So may I thank you very much, and it was really candid presentation, and I like it. I actually like it. On the other hand, let me turn the floor to Captain Andy for the introduction of our fifth speaker, second to the last. Thank you very much.
Thank you, Anna. The fifth speaker from the Chinese side is Mr. Tingting LUO, Associate Research Fellow of National Marine Data and Information Service. Ms. Tingting LUO, please, the floor is yours.
Okay, thank you. Thank you, Captain Andy, and good afternoon, ladies and gentlemen. I'm Tingting LUO from National Marine Data and Information Service. It's my great honor to discuss the issues here with all the experts. Today, my presentation will focus on the significance, obstacles, and wise choices about the oil gas joint development arrangement, JDA between China and the Philippines. Now I'll begin my presentation. As we know, JDA is a provisional arrangement and unclosed, and is widely accepted in state practice. Further, setting the boundary in areas of overlapping claims may require a very long negotiation, so the unclosed caters for the fact that provides a temporary solution to this situation. In paragraph 3 of Article 74 and 83, these solutions include moratoriums on resources exploitation pending final delimitation and an obligation to take every effort to make provisional arrangements and not to jeopardize or hammer the reaching of a final delimitation in the interim. But as we know, the UNCLOS does not mandate the type of provisional arrangements states can enter into, so it leaves it to the discretion of the states concerned. But there is no doubt that JDAs are one of the provisional arrangements. Indeed, it appears to be the most commonly used arrangements for overlapping claim areas. As the judicial decisions, the international courts and the tribunals have also endorsed joint development agreements as an alternative to maritime delimitation. For example, in the North Sea continental shelf cases and the Tunisia and the Libya case and the Eritrea, Yemen arbitration, etc. In the North Sea continental shelf case, the ICJ holds that joint exploration agreements were particularly appropriate when it is a question of preserving the unity of deposit in areas of overlapping claims. For state practice, as we know, there are many precedents setting for the JDAS. For example, the Japanese-South Korea arrangement was the first offshore oil development in East Asia. The Timor Gap arrangement, by far, is the most detailed one, and it still remains a good model for joint development in the world. The Malaysia, Thailand, and Malaysia, Vietnam joint developments are successful models in the South China Sea. So, in conclusion, cooperation to management and exploit shared marine resources may be a better solution for setting overlapping maritime claims than waiting for an agreement to reach after a long negotiation progress. Now, I will come to the significance of Sino-Philippines JDA and some consensus achieved by both sides. As we know, the South China Sea has sometimes been labeled as the new Persian Gulf. The increasing demand for energy that China and the Philippines are facing can be viewed as the most important economic incentive to jointly exploit oil and gas resources. Both countries need a good environment for social and economic development. The obligation of good faith in the context of South China Sea means we are willing to negotiate maritime boundaries or joint development zone with an open mind. As we know, JDA can create a good atmosphere for resolving Sino-Philippine maritime dispute peacefully, also enhance and expand bilateral cooperation. There are two conditions necessary before there can be serious discussion on joint development arrangements. First, joint development agreements tend to be concluded in periods where good relations existed among the relevant parties. Second, the parties must have the political will to make decisions that may face oppositions within their countries. Now, we'll see some obstacles between the two countries. There are so many factors that involving with the JDAs. As we know, the political will, the domestic public opinion, and the recognition of overlapping claims, and the external interference. As we know, negotiating joint development agreements are very complex. So it requires considerable expertise and commitment of time and resources. A high level of political will within each state is necessary to achieve this progress. And the domestic political opinion is very important too. It's an important fact that both sides should consider. As we know, in Philippines, many people are concerned that the JDA is a breach of the 1987 Constitution of the Republic of the Philippines, because the Article 20, Section 2, as follows: all lands of the public domain, waters, minerals, coal, etc., and other national resources are owned by the state. Exploration, development, and the utilization of natural resources shall be under the full control and the supervision of the state. So some Philippine people will think that is really a breach of the Constitution. The external interference is also a big obstacle for the development. The US have put forward some reports concerning the settlement of oil, island, and the fishery dispute in South China Sea. It wants to set restriction of China's power imposed by the mechanism of joint development. I have read some essays, and I have seen that some scholars from the Asian countries even said that. They say the Chinese proposal has the intention of enhancing de jure access to dispute areas while it maintains de facto control of the area. So what should we do next? In my opinion, there are some wise choices. We have to confront the obstacles, and we should choose what we should do. For both sides, it's very useful, it's meaningful to both countries. First, as we know, the MOU between China and the Philippines have been signed in 2018. The consensus achieved by both sides should be respected. Both sides should have a certain level of trust in each other. Pending the dispute and finalizing the without prejudice provision is very important. As we know, the without prejudice provision, it ensures that whatever arrangement agreed to will not affect the final boundary agreement. A JDA gives the states the opportunity to exploit the resources without giving up their claims to sovereignty or sovereign rights in the joint development area. So agreeing to a joint development area, in fact means sharing the dispute for a generation or two, while enabling both sides to benefit from the exploration of the hydrocarbon resources in the agreed area. In fact, China has been devoted to promote good faith in the South China Sea in recent years. China has reaffirmed with the Philippines that it will address territorial and jurisdiction disputes by peaceful means, increasing mutual trust and confidence, and to exercise self-restraint. China high-level diplomats have also demonstrated goodwill to the ASEAN claimants in recent years. For example, Cui Tiankai, former Chinese ambassador to the US, said that China is not trying to take back the islands and reefs that are illegally occupied by others. That's the remarks at the Center of Strategies and International Studies in 2016. Chinese government has also educated the public on the benefits and importance of joint development and emphasized the fact that it does not involve a surrender of sovereignty. So I think it's very necessary for both governments to report the concerning issues to citizens and gain their support. Chinese mainstream media have paid close attention to the conception of pursuing joint development while shelving disputes since 2017. Chinese government has made great efforts to manage domestic politics and tone down the nationalistic rhetoric associated with the South China Sea dispute. So successful negotiations for COC may help to create a conducive atmosphere for the joint development in the South China Sea. We have to build our strong trust between each other. In order to lower the difficulty of the negotiation, I think we should set a transitional period to reduce the obstacles and try to deal with substantive and technical issues first. I have seen that someone have left the questions online. Is there a time limit for the MOU? The answer is there is no. There's no time limit. So it leaves more time for us to deal with the obstacles. So we can have enough time to reduce the obstacles. The last one is that written agreements provide a legal basis for the scope of joint activities under consideration, are certainly preferable to the ambiguous arrangement. So the precise terms of an arrangement may provide limitations on joint activities and protect a state against less forcible consequences and the factual changes that might occur. So I think that an important strategy to protect states against unforeseen or long-term consequence would be to include provisions on the duration and unilateral termination of an arrangement. There is something I want to say that China has, there are plenty of work that China and the Philippines can do. For example, China needs to provide more public goods such as navigation safety, environment protection, maritime salvage, and weather forecast. That's my presentation. Thank you.
Thank you, Dr. Tingting, for giving awareness to the importance of international practice and jurisdictions and regarding the joint development areas. You also, I think, I can also recall the previous speakers, Dr. Melissa, both, I think at least 3 speakers have mentioned the constitutional strengths on this issue. I'm not a constitutional expert, but I would like to ask a question for maybe further deliberation after the meeting. As Dr. Melissa also mentioned, there are seldom GDA joint development practice regarding the overlapping territorial areas, and also sort of her response to one question: if there is no overlapping areas, there will be very difficult for joint development. My question is, if whatever kind of agreement is reached by both governments, I think it is a kind of exercise of sovereignty, not giving up sovereignty. Take the status of forces agreement, for example. Normally speaking, foreign armed forces is not allowed to station in one sovereignty state, but by signing the status of forces agreement, one country, by exercising the sovereignty, can take the foreign armed forces in their territory. So this is one of my questions for further discussion. So without further delay, I'd like to turn over the floor back to Anna. Anna, please.
Yes, thank you, Captain Andy. Yes, I think we can ask questions later. So to introduce our last but not the least speaker, he is Professor Celso L. Cainglet, a senior lecturer at the University of the Philippines in the Visayas. His career and professional life may be described as largely academic in nature, serving as a faculty member in various university colleges and institutes in the country to the present day. Professor Cainglet is one of the awardees of the Award for Promotion for of Philippine-China Understanding this year, 2022. Ladies and gentlemen, join me in welcoming our last speaker, Professor Celso Cainglet. Professor Celso, the floor is yours.
Thank you very much, Anna. Thank you very much, Captain Andy. And most of all, thank you very much to our distinguished speakers. I learned a lot from you, and many of you confirmed my position this afternoon. I will take a slightly different path because I know that the question posted earlier will be tackled already. You know, it's already 2022, and I cannot believe we're still discussing about boundaries. You know, these territories, these national territories are 18th century construct. In a globalized world, they are being eased out already. What I'll do, I'll attempt to elucidate on the complex Philippine political milieu and how it hinders development and impedes the country's participation in the rising economy in Asia. Dr. Yang Li, Dr. Tingting already mentioned about the importance of the local political dynamics, and I will more focus on that so that we will have a better appreciation of what really happened, why this conflict escalated. Because I believe that the laws, the technicalities, they're very flexible. If there's a will, there's a way. In fact, even UNCLOS states that if there is an overlapping dispute, they leave it to the two countries to settle the matter themselves. Okay, so UNCLOS is flexible when it comes to territorial dispute, leaving most of the solutions to the countries in dispute to settle the matter diplomatically. However, due to the patronage politics and hegemony of the oligarchs in the Philippines, settling disputes have become more complicated due to the vested interests of particular groups. Personally, I don't see any major problems in the technicalities of the joint gas and oil development cooperation between China and the Philippines. More so, I don't see any problem on the side of China. The problem I see is on the side of the Philippines. The problem is more on the social political factors that beleaguer Philippine society. This will be illustrated by briefly narrating the recent historical events, particularly during the presidency of Benigno S. Aquino, that led to the escalation of the conflict between the Philippines and China. The previous administrations prior to Aquino did not have any major discord with China. There were slight irritants during the presidency of Fidel V. Ramos due to his alliance with the United States. Ramos would once in a while toe the line of U.S. interference in the Indo-Pacific region. The height of Philippine-China stable diplomatic relation happened during the presidency of Gloria Macapagal Arroyo, and only to plummet during the presidency of Aquino. I would like to acknowledge Bobby Tiglao, a local journalist and former press secretary of the Office of the President, who did most of the extensive research on the historical events that led to the escalation of Philippine-China territorial dispute. So what really happened? There are three groups interested in the hydrocarbon deposits at Reed Bank. The First Pacific Company, owned by the Indonesian Anthony Salim, who also owns a vast majority share in Felix Mining, a subsidiary of PXP Energy, formerly Felix Petroleum Corporation, which owns Forum Energy. Salim's man in the Philippines is Manuel Pangilinan, who owns several multi-layered companies in the Philippines. Salim's partner in the Reed Bank project is the casino magnate Enrique Razon. Third, Roberto Ongpin, who has 20% of Forum Energy. It was Ongpin who led the investors group in 2008 to sell the last tranche of Felix Mining to First Pacific. On February 10, 2009, the Energy Department issues to Forum Energy, the firm of Salim conglomerate known as the First Pacific Group, Service Contract Number 72 to extract gas and oil in the Reed Bank. In a note verbal, China protested the issuance of Service Contract 72. A similar protest was issued on May 13 when Benigno, on May 13, when Benigno Aquino III became president in 2010, he appointed Salim conglomerate executive Albert Del Rosario as Foreign Affairs Secretary. On February 30, 2011, Forum Energy dispatched seismic survey vessel MV Veritas Voyager to the Reed Bank in the Spratlys. On March 2, 2011, China's civilian CMS vessel, China Marine Surveillance Vessel, blocked Forum's vessel, saying it did not have the authority to explore for gas and oil in the area. On July 25, 2011, Aquino, in his second State of the Nation address, ranted against China for blocking the Forum Energy vessel. He claimed what is ours, and announced his plan to file a case in the International Tribunal for the Laws of the Sea. On the side, when Rosalind Higgins, the first woman president of the International Court of Justice, already declared that nobody owns those hydrocarbon deposits because they're transcontinental transboundary movement under the continental shelf. No? It's only when you capture it that the law of capture applies. The Philippines does not even have the law of capture. The model for these are the Nordic countries. According to Bobby Tiglao, what triggered the tension between the two countries was China's driving away from the Reed Bank on March 2, 2011 of an oligarchic trio vessel, MV Veritas Voyager. Aquino was implacably livid about the incident as if he has a personal stake at it. The Aquino regime concealed the involvement of that private consortium in the Reed Bank incident. It lied to Filipinos, saying it was Scarborough Shoal standoff from April to June 2012 and the resultant loss of the shoal that triggered its filing of arbitration case against China. The original plan was to file a complaint at the International Tribunal for the Laws of the Sea, but was cancelled upon the advice of the international law firm Foley Hogg, for it involves sovereignty claim and will be surely tossed out by ITLOS, for it cannot be resolved by UNCLOS or court. The law firm instead advised that it be packaged as an arbitration case on maritime entitlements and not on sovereign disputes. During the height of the tension, China was willing to discuss diplomatically with the Philippines in a bilateral dialogue. But the Philippines, upon the advice of Foreign Affairs Secretary Albert Rosario, who follows his American masters and his boss Anthony Salim, insisted on a multilateral talk involving the United States of America. China refused a multilateral discussion. Why did America wanted to join in a fray? As Asians, when there is conflict with our neighbor, as much as possible, we avoid going to court. We settle it among ourselves, or we call uncle to mediate on the settlement. The Aquino administration brought the matter to the Permanent Court of Arbitration at The Hague. China did not participate in the arbitration, so technically there was no arbitration that took place. The arbitration panel ruled in favor of the Philippines, expectedly since the PCA is a private company and it was paid with a huge amount of money by the Philippines amounting to 1 billion pesos for the arbitration proceedings, and expectedly will rule in favor of its client. In the first place, I don't think the panel has the capacity to rule or the authority to rule. If you read the decision closely, it does not tell China to do anything. And technically, the PCA cannot make such a ruling. But the Aquino administration, through its mouthpiece, Associate Justice Antonio Carpio, made it appear that the PCA was a United Nations body, and the ruling was a victory for the Philippines. They lied again. The Department of Secretary Affairs hired a Washington-based NGO, the Center for Strategic and International Studies, alleged to be a CIA front, to help strategize the countries dealing with China. It was the CSIS who crafted the media operations to demonize China, to make China appear as a bully who grabbed Philippine territory. They launched a well-oiled media machinery, tapping mainstream media outlets and new media outfits such as Rappler, Verifiles, and so on. The National Endowment for Democracy is one of the funders for the operation. They harp on the Filipino Cinderella complex, that is, the feeling of Filipinos as underdogs being bullied by the rich and powerful. Filipinos have already a primordial xenophobia inculcated by the Spanish colonizers. The Spaniards then were threatened by the progress of Chinese traders that they drilled into the minds of Filipinos that the Chinese cannot be trusted. Aquino took the cudgel for the triad's business interests, putting the nation in jeopardy not only in the possibility of war with China, but endangering its economy since China is a major trading partner. Aquino's minions, DFA Secretary Albert de Rosario, who apparently had the interests of his boss Anthony Salim in mind, and then Defense Secretary Voltaire Gasmin, frequently made a trip to Washington begging for American assistance in the South China Sea conflict. The Americans would make great promises, citing the Mutual Defense Treaty of 1951, but at the end of the day, would advise them to settle the matters with China diplomatically. Aquino also went to see Barack Obama, requesting the United States Navy to escort Philippine ships going to the shoal, but Obama said no. Way back in the 60s, the Philippines almost went to war with Malaysia over the Sabah claim, and the Americans categorically denied assistance. During his presidency, Fidel Ramos went to U.S. Ambassador John Negroponte seeking assistance from the U.S. on the intrusion of Chinese vessels at Spratlys, but was advised to settle the matter with China himself. Aquino's passionate ranting for the sake of the oligarchic triad formed assumption that he may have a stake in one of the companies, and indeed there were allegations that his family had a stake in the project, which would generate billions of dollars from the hydrocarbon deposits at Reed Bank. So local politics, vested interests, not the technicalities, not the Constitution, because in fact, the Constitution can be amended, are, I believe, in my opinion, were the major factors. And the Filipinos were deceived. And because usually when discussion on the South China Sea issue were conveyed, they are very, very technical, and the ordinary people could not understand them. That's why Professor Ana and I were just talking 2 days ago that we have to come up with a good communication plan and look for a platform in which we can explain to the people in a very, very simple language what really happened. Because the support of the masses, the support of the people is very important. Take note, our leaders are politicians, and politicians respect numbers. So if there's a pressure from the people, if there's a growing consciousness within the Filipino people, what really happened, and they were deceived by mainstream media. Hopefully, all those technicalities will be set aside, because even our present president, Ferdinand Marcos Jr., when his father, Ferdinand Marcos Sr., went to China in 1975, he talked to Deng Xiaoping. I think at that time Deng Xiaoping was just vice premier, and he brought up this issue on the dispute, on the territorial dispute. And Deng Xiaoping told him, let us set that aside. Let's do business. Let's leave that to the future generation. Maybe the future generation will have more wisdom to deal with the issue. And personally, I believe maybe in the future, these boundaries, these territories in a globalized world will be eased out. Thank you very much.
Thank you very much, Professor Celso Cainglet, for that. I think for me, as Professor Celso explained more the domestic, domestic issues, more political issues, no? While there is this kind of, how would I call it, well, it contributes to the obstacle, I think, of forging good relation with China in a way, especially when you talk about a very sensitive issue like the South China Sea, precisely because there are also local and domestic politics that are coming into the picture. And I think that's what Professor Celso is trying to share with us. No, so this is more on localized perspective. Yeah, and I thank you for that, Professor Celso. At least in this webinar, we have different perspective, no, coming from historical perspective, coming from a legal point of view, and also from a political and socio-political point of view, which would give us more a macro and micro view of the whole gamut of issues that surrounds the South China Sea, and more particularly the concern as to the joint oil gas development cooperation between the Philippines and China. So that I think this webinar is successful in that sense. Captain Andy will move to the second part of the webinar, but you know we are pressed for time. It's already 5:28. I think both in Beijing and also here in the Philippines. So probably we should just have one question addressed to everyone, to all our speakers, and then we will close the webinar. Do you have a question, Captain Andy? There are a lot of questions in the Q&A chat box, but I think our good speakers, our excellent speakers have addressed, and most of it actually, Dr. Melissa addressed the questions of some of our participants for this webinar. Yeah. And also Dr. Yang also addressed some of the question. Yes, but any question that you want to pose to our speakers, if you have one, Dr. Andy, Captain Andy.
Not yet. I think most of the questions have been addressed by our speakers. Yes. Thanks very much. I think, Anna, since we are already beyond the time, although that shows the enthusiasm of our audiences and the speakers, maybe I think we can close the meeting.
Yes. Okay.
And, also, I would also say just one point. Many issues have been touched upon. This is a series meetings. So for the next round, I will talk about it with Anna. We are going to cover other issues that have been mentioned by our speakers. Thank you very much.
Yes, and also just for the information of our speakers and the participants of the forum, we are live in different social media platforms, in Facebook of the Manila Times, and even in my own Facebook page, and in GTNR Facebook page. This is a media entity as well. And thus far, we have a lot of people who watch and even stayed until now, watching the whole webinar. In Manila Times, it reached up to 104 people, no, and I think it will be watched as you know, it's there already in Facebook, so other people can watch the replay. So this is really a very successful webinar thus far, and so let me close the whole forum. To our distinguished and esteemed speakers, to my co-moderator for this afternoon's webinar, retired Captain Andy TIAN, who is the founder and president of the Global Governance Institution, to the co-organizer of this webinar, the Asian Century Philippine Strategic Studies Institute and the Integrated Development Strategic Studies. These are think tanks based in Manila. Ladies and gentlemen, friends and colleagues, once again, a pleasant, almost evening already to all. The bilateral relationship of the Philippines has already reached to a comprehensive strategic cooperative relationship, which means that there's a deepening in the practical cooperation and managing of differences between the two countries. Concerning the differences between the two countries in the disputed South China Sea, I think what is important is the way to handle these differences. There's a need to continue to handle it properly by the governments of both countries, the Philippines and China. Both sides need to look at these differences with a proper perspective and must not allow these differences to overshadow the many good things and benefits that the deepening friendship mutual understanding and cooperation between the Philippines and China are generating and producing for the good of both countries and their peoples. The Philippines and China are close neighbors and are destined to be Asian brothers because of the geography, no? We cannot avoid that. It's really there. Thus, the two countries are brothers that need to get along together peacefully and cooperatively. There's so much to look forward to as we pursue to achieve mutual beneficial and win-win cooperation between the Philippines and China. And I think the pursuance of joint oil and gas development cooperation, or whatever possible cooperation that we can come up with in a creative manner, in terms of utilization of the marine resources in the disputed South China Sea, is there to unfold. I hope that both our governments will persevere in making all this happen for the benefit of the Filipino and the Chinese people. On this note, I would like to congratulate and extend our sincere thanks to all our distinguished and esteemed speakers for sharing their knowledge, experience, and ideas on this issue. And actually, not only on this issue, but on so many things. Actually, I've learned a lot from this webinar. I would like as well to extend my heartfelt thanks to all who attended this forum, both live stream on social media and also via Zoom. Likewise, I would like to recognize and express our sincere gratitude to the Manila Times for covering this webinar. The Manila Times is the official media partner of this webinar. Ladies and gentlemen, once again, thank you very much, and I wish you a pleasant early evening and relaxed weekend. So thank you so much, and hope to see you in our next webinar. We're arranging some kind of dialogue between the two parties, no? China and the Philippines, but this is much more, I think, people to people level, not the state to state, no, but people to people. So see you again in our next webinar. We will be sending invitation as well. Thank you so much.
Thank you.
Thank you.